Everyone to tonight's. Thank you, Susan. I'd like to welcome everyone to tonight's presentation, Extended School Year Services and Compensatory Education, What Parents Need to Know. Tonight's event is being hosted by two organizations that provide support and advocacy assistance. The first is ASA, ASAH. Joining us tonight is Susan Reese from ASA. Susan, you want to just say hello?
Yes, hi. I'm glad everyone's joining us tonight. Thank you for that.
Okay, fabulous. And the Alliance of Private Special Education Schools of North Jersey. Both organizations are made up of state-approved private special education schools that serve students with disabilities. Students are served at no cost to parents, typically through the IEP process. So the Alliance does a whole lot of work and outreach to help support families. And I'm going to indulge you for just a minute and share my screen, if I can. I'll temporarily disable the screen that's being shared. The screen that I'm showing you right now is the Alliance of Private Special Education Schools of North Jersey. This tells you a little bit about who we are, the work we do, and the supports that we provide for families. And I'm sharing this right now because we have an event coming up on Saturday, March 25th. It's a family fun day and special needs resource fair. The event's free. We've got games, face painters, superheroes. It's a lot of fun. So if you haven't registered for that yet, I encourage you to check out our website. I'm going to put that in the chat. I also want to let you know that we have a $1,000 scholarship for graduating students with an IEP or 504 plan who are graduating from a public school program. We're really celebrating the skills and abilities of all students. So we want to make sure that we are offering scholarship support for students with a range of disabilities from public schools. I'm going to stop sharing now and let our guest speaker start to share. Okay, fabulous. We've got a couple more people coming into the waiting room. So as we get started, I'm going to introduce tonight's speakers, but first, you know, when we're not together in the same room, it's hard to get a show of hands, but I'm wondering if we can use the chat to just let us know how old your sons and daughters are. So we have a sense for who's in the room tonight. That'll let our speakers more specifically tailor some of their examples. So if you can just use the chat feature to let us know how old your son or daughter is, that'll help us out a little bit. And as you do that, I'll introduce tonight's speakers. So tonight's speakers, we are thrilled, by the way, to have the benefit of your expertise, your wisdom, your long-standing work in this area. We're joined tonight by Denise, Dimson, Rekem, and Judith Weinstock. They are attorneys in private practice at Parles Rekem, attorneys at law. I am going to put a link to their practice in the chat so you can learn a little bit more about each of them individually and the good work that they do. The firm focuses on representation of people with disabilities and their families in the area of early intervention, special education, transition, adult services, residential placement, guardianship, and discipline. Their reputation is stellar, and we really, really appreciate you being here tonight. So, okay, good. Thank you. Susan's already got that link in the chat. So it looks like we've got quite a point spread in terms of age. This is exciting. 14, 15, 14, age 9, 16, 16, 14, 19, 10, 17. Looks like a teacher or maybe a school administrator, students ages 13 to 16, 6-year-old twins, 18, 15, and 14 to 21. And 13. So that gives you a sense for who's in the room. And with that, I am going to turn it over to Denise.
Hi everyone. Nice to see everyone's faces, even on the screen. Denise Rekem, partner at Parles Rekem Law Firm, and we are very happy to be here with you. We're going to do a brief PowerPoint presentation, but we're happy to answer questions. If you put the questions in the chat, Brenda will monitor that and let us know. We'll probably take most of the questions at the end. But if there is something that we say that you need clarification on that's confusing, please put it in the chat and Brenda will interrupt us and ask us to clarify, because we don't want to keep going on if there's some kind of misunderstanding happening. So Judy has the PowerPoint. Can you get, okay, thank you. So before we get into the specifics of what we're going to speak about tonight, we just wanted to back up a little bit and give a little context to the rights of students with disabilities that give rise to ESY and compensatory education and everything else we're going to be talking about. So bear with me, I'm going to be quick if most of you have heard this before, but the two laws that are most impacting children with disabilities are Section 504, the Rehabilitation Act, which is really an anti-discrimination law. It's about allowing children with disabilities to have equal access to the same opportunities as students without disabilities. And then there's the Individuals with Disabilities Education Act, the IDEA, and that's where the IEPs come from. And that's really, it's not just about access, it's about allowing students to make progress, to move ahead and gain skills in the areas that they need for their disabilities. Those laws and New Jersey state regulations, which are implementing those laws, are the guidance for the districts and for us in what children with disabilities are entitled to. And then there's case law. So those laws have been interpreted by different courts and, courts in our circuit, the Third Circuit, where New Jersey is, which is the federal appeals. And then, of course, the Supreme Court. Next slide. So what is the IDEA's mandate? The Individuals with Disabilities Education Act entitles all children who meet the definition of a child with a disability. So that's those different categories that they put in an IEP, hearing impaired or other health impaired or autism, blind, deaf, different categories. Those children are entitled to receive a free appropriate public education, or a FAPE, in the least restrictive environment. Next slide. I just want to mention two different, because we're going to be talking about this later on as they relate to compensatory education, but the IDEA, it goes from age 3 to age 21. And the child with the disability with the IEP is going to high school. They're going to be a 12th grader. And then the IDEA has this transition part where the child is no longer necessarily taking, math and science and those things, although if they have a big deficit in, say, reading or math, those skills can continue to be taught. But generally, transition is talking about what are the skills that the child needs for post-secondary education, for vocational, integrated employment, supported employment, depending on the needs of the individual student, independent living, community participation. Those are skills that are being focused on during the 18 to 21 transition years. So while not every child who has an IEP necessarily requires a transition program, they have to look at it. So if you had a child, for instance, who had dyslexia and the IEP was focusing on the dyslexia and giving the services, and by the time the child reaches 12th grade, they're doing pretty well and they're ready for their next step of life. It just because they have an IEP doesn't mean they have to have a transition program, but it has to be discussed. It should be discussed starting at age 16. It should be discussed with the team of whether this student is someone who's going to need these post-high school transition services. Next slide. the other thing which we're going to be talking about later is ESY, extended school year. These are programs that are in the summer for the student, and they're a little bit different than the program during the academic year. So during the academic year, the child has goals and objectives, and they need to make progress in those goals and objectives to have a free, appropriate public education. The calculation for extended school year is about regression and recoupment. Every child over the summer loses a little bit of learning, and that's why they go back to school and there's a review happening at the beginning of the year. But if the IEP team feels that the loss in learning is so great that the child is not going to easily make up that loss of the summer, then they need to provide extended school year services. So again, you're talking about services that are aimed at not so much progress, but not allowing for the learning loss. Next slide. Okay, I'm going to turn it over to Judy.
So Judy, before you get started, we had a question about twice exceptional students, and I answered in the chat, yes, they are eligible, but it's perhaps a little more nuanced than that. If you just want to address that real quick.
Yeah, so the question is, does the IDEA cover twice exceptional students? So the answer is that the IDEA doesn't speak exactly to twice exceptional students. However, the disabilities that are covered under the IDEA are certainly disabilities that coexist with twice exceptional, with high IQ. So you have a child, say, with high functioning autism or with ADHD or anxiety, those disabilities that would be covered under the IDEA with an IEP. And then there's other law in New Jersey that school districts are supposed to program for students with high IQ. So these are, so I'm not sure, I hope I'm answering this in a way that's comprehensible, but it's not that an IEP would necessarily talk about the high IQ part. The IEP would be focused on the services and supports that are needed for the disability. However, if a child is getting frustrated because they're not being challenged and that's leading to behaviors, there is, there's obviously going to be overlap where the twice exceptional part of it is coming into play, but it's not a category of the special education law, so it's not exactly covered. And there are gifted plans, so a child could have an IEP and a gifted plan, and they should obviously work together.
I'm just going to drop a link in the chat. This is an article that appeared in Common Ground. That's just a simple Q&A on, very simple Q&A, sort of summarizing some of the issues on ESY. Okay, thanks.
Okay, so I just wanted to add that, you can have a child who's twice exceptional, who's in an honors program, for example, but that they need either accommodations or modifications or even some type of intervention to address the disability that qualifies them under the IDEA. So it does cover it as long as, like, as Denise was saying, that you have a disability, there is a disability that is one of the disabilities pursuant to the statute that makes you eligible as a classified student, and it comes into play where that a child who may be twice exceptional, they're in a gifted program, but they need the interventions that would be provided through an IEP or a 504. So thanks to Denise, we have the groundwork of what districts are obligated to provide students who are classified. Their districts are required to provide FAPE, or free appropriate public education. So now we come to the special part of this, which is COVID happens, which is a complete disaster and throws a monkey wrench into all sorts of aspects of our lives, including education, and in particular, for our purposes, special education. So basically what happened is in March, the schools closed down, the buildings closed down, and there's this great question about how to educate students, and in particular, for our purposes, how to educate students with disabilities. And basically, the federal government, the Department of Education, puts out an education guidance in March of 2020. And it provides that school districts must continue to ensure that students with disabilities are provided FAPE, free appropriate public education. And they put this standard, or this caveat, next to the sentence, and it says, to the greatest extent possible, in consideration of all that was going on at the time. But it did not waive any obligation of the district to provide FAPE. It did not, and we'll get into this more specifically later, but basically, at the time, in fact, Denise and I were discussing this, that, Congress did not waive any of the specific obligations pursuant to the IDEA. It still required the districts to comply with the law. It did not make any exception because of COVID. And FAPE is, at minimum, the special education and related services identified in the student's IEP that's developed under the IDEA, or a plan developed under a Section 504. That was at minimum, and that was reiterated in the guidance. In addition, pursuant to the guidance, there was sort of a, not sort of, but there was this provision that said once school buildings reopened, that the IEP team would need to determine whether there was compensatory services required to ensure FAPE. So they recognized, with all the turmoil and the closing of the school buildings, that there might be some missed services or interventions that were not provided pursuant to an IEP, or the means in which it was provided that would need to be made up at a later time through compensatory services. So what is compensatory education? Oops, I'm sorry, went ahead there. Compensatory education is a concept that existed prior to COVID, as probably many of you are aware. And I like this quote from this case, this Third Circuit case, which is our circuit. New Jersey is part of the Third Circuit Court of Appeals, which provides the purpose of compensatory education. And it states compensatory education aims to place disabled children in the same position they would have occupied but for the district's violations of IDEA, by providing the education services children should have received in the first place. So that's sort of the standard in the Third Circuit, that there is some kind of provision of services or interventions that were not provided, and that we need to rectify that. It's basically, compensatory education is an equitable remedy, which it's basically a remedy that was designed and recognized by the courts. It's not in the statute. There's not a provision in the IDEA or in Section 504, the Rehabilitation Act, that provides specifically for comp ed. It is a remedy when courts when these cases are filed, that services haven't been provided, that the courts have designed to remedy the situation. It provides for additional interventions, services, and supports to students who in the past, like I said, have been denied FAPE, or whose IEPs have not been fully implemented. It's in addition to the current program. So in other words, it's in addition to the special education and related services the student would otherwise receive going forward. So if your child or if your student has a current IEP, but they missed, but other services were not provided to them previously, if they're owed those services, those are in addition to the IEP that they have right now. So another guidance came out from the New Jersey Department of Education. I mean, several guidances came out throughout this period of time from the United States Department of Education and the New Jersey Department of Education. This one, for our purposes, specifically addressed compensatory education during COVID. And it was issued on March 3rd, 2021. And it provided that comp ed would be provided if it was determined that failure to receive services caused a denial of the student's right to FAPE. So this is a little different. This is a guidance that's saying, okay, let's talk about compensatory education and COVID and what was missed during COVID. And it provides a guidance to the districts, okay, to explain how to determine compensatory education. And it does this by saying they need to see if the failure to receive services during COVID caused a denial of the student's right to FAPE, caused a denial of FAPE. It's suggesting that the IEP team, the guidance suggests that the IEP team review the impact of missed services on progress toward goals and objectives during COVID. So this is kind of different than, and we believe conflicts with case law. This is different from what we were mentioning, or I mentioned in the previous slide, which is that, basically our case law, the courts of appeal, the appellate courts, the federal appellate courts have held that students are entitled to compensatory education if there is more than a de minimis failure to implement the student's IEP. And moreover, the Third Circuit there's precedent in the Third Circuit, there's cases in the Third Circuit, which are listed here, from 1990 and 2014, which provide that there's actually this idea of one-to-one relief. So for example, if a child or a student missed 18 hours of, or wasn't provided 18 hours of occupational therapy, hypothetically speaking, in an IEP, then they could, for the relief requested, they could potentially receive as comp ed 18 hours of occupational therapy. So a one-to-one, like 1 hour to 1 hour, or if it was 2 times a week of speech language therapy and they only got 1 time a week, then they're owed that 1 time a week, and you quantify how many weeks that child was not provided the therapy. So this is a little point of contention between the guidance that was issued in 2021 by New Jersey and what we believe the case law provides for. And unfortunately, there's just very few opinions thus far with respect to COVID Comp Ed to determine whether the courts are going to hold by their precedent and what they've established previous to COVID, or whether they're going to, possibly adopt or incorporate what the guidance provided as an exception for COVID, for compensatory services during COVID.
I've put a link to the DOE memo and the actual decision that you're referencing for those policy wonks out there in the chat.
Great, thank you. Thanks, Brenda. Overall, compensatory education may be indicated for a failure to receive special education, direct instruction, and supports included in the IEP. Or if, I'm talking about COVID, if the student was provided virtual live instruction and services per their IEP, but they were unable to access it or, participated in it in a meaningful way, then that would also indicate that compensatory education would be in order. Now, I do want to mention that at the beginning, especially in the beginning of COVID, when the school buildings were shut down, that many districts across the state were providing packets, like learning packets, and sending websites out and teacher check-ins. I mean, under the circumstances, I think they were trying to do the best they could, but just significantly for the issue of compensatory education, this is not the direct instruction that is required for FAPE. So considerations, if you feel that your child was not provided with the interventions that were included in their IEP, you can basically look over the IEP services and instruction, what was in the IEP or the 504 plan, and check to see what was included and what was not included. The frequency and duration of all the services and the instruction that were provided, how often, if, like I mentioned before, if during this period of time, there was only 1 time a week of occupational therapy or speech language, or if the instruction or the intervention was provided virtually, which is very difficult, especially in when you're talking about related services like occupational therapy, to be provided virtually, and were not really accessible for children. And in general, whether the services or the instruction provided, whether the child was able to access it at all, did they benefit from that manner or the method or the strategy that was used? And basically, if they were, many students were unable to access virtual or remote instruction at all due to various reasons, their disability, ADHD, behavior, and just other learning disabilities that would impair access to virtual learning. The other thing that I think needs to be considered or should be considered, we advise parents to consider, is if during this time there was a request for initial evaluation, the child or the student was referred to the child study team for evaluations, if the triennial evaluations were due at this time, or an IEP meeting was due or requested, and it was delayed or did not occur at all during the COVID pandemic, that gives rise to compensatory education. Basically, if there's any kind of delay, if there's an initial evaluation delay, and let's say after the pandemic, 2 years later, the child is classified and does need services, then you're talking about that period of time where the child went without those services, and they're owed that under the IDEA, under the compensatory education provisions, and also a case law, and also even under the guidance of the DOE, of the New Jersey DOE. Okay. And then, the other thing that we like to tell parents is to think about whether new or different needs came about as a result of COVID-19. So many students were impacted by school closures and by the virtual hybrid learning, and whether it was changes in behavior, the raising of new learning challenges as a result of the COVID closures, because of either lack of access or not being able to engage with peers, or the social and emotional needs that might have evolved from the pandemic.
I'm going to just drop in a quick question here that sort of sums up too. What about related services, social skills groups, speech therapy? What if the hours were provided, but remote Zoom just didn't work?
So that's the same thing. If those were, it was very difficult to access learning in general remotely, but especially for things like speech language or social skills or peer engagement. Those were really challenging to be an effective means of intervention. And if your child was unable to really get anything out of it, if they didn't receive the benefit and it was supposed to, it's in their IEP, then that definitely would trigger a concern that they need the compensatory education, or would rise to the level of requesting compensatory education for those services.
Thank you.
So, oops, sorry. Keep on. Hold on just a second. So just another reminder that, there was no waiver of the obligations under the IDEA, and that includes all the timelines that are specifically delineated in the statute, in the IDEA, in the law. And so in other words, the 60-day time requirement to complete evaluations and the annual requirement for IEP meetings, those were still in effect, and the district had an obligation to provide them. Now, obviously, it was really difficult to provide those things and to comply with that. We're not putting blame on anyone. We don't think that they acted maliciously or they were negligent, but it doesn't matter, because what the provisions of the federal guidance provide, and New Jersey, is that what the missed services, which includes these timeframes, these specific deadlines and timeframes, result in the preventing the child from receiving FAPE, not providing them with a free appropriate public education. So just keep that in mind as well. And then just as far as assessments go, a lot of times the districts were saying that they couldn't perform the assessments during this period of time, basically because they couldn't do in-person assessments. So there was this whole discussion around in-person versus virtual assessments. And basically what happened was this was determined, it was a case-by-case determination. And for the most part, virtual assessments became just almost as valid or just as valid as in-person through the professional association putting out standards and test publisher guidelines. So professionals were doing these assessments virtually pursuant to these specific guidelines or standards that were put out during the time of COVID. So like caveats or acknowledgements that it was being done virtually, or certain modifications or modifications to the assessments to accommodate the virtual, so that there could be confidence in the accuracy of the assessments. And my experience with working with the professionals during this time that were doing the virtual assessments is that they had a high confidence level of accuracy, and the districts were, for the most part that I worked with, but Denise might have a different experience, accepted them as valid. The other thing is, so if there wasn't an assessment during this period of time, that also would be a means of, comp ed, that they have to conduct those assessments now. If there was a determination of eligibility or for the addition of services in the IEP, which was delayed, I mentioned this before, the student may be entitled to compensatory education. So that's exactly what I mentioned before, that any delay in the timeline as to referral, assessments, and providing an IEP would or could result in entitlement to compensatory education. And I don't know if there's any questions, but I can hand it
Yeah,
over.
we've got a couple coming
There's
in.
a few.
Okay.
I think I'm going to talk to a few of these questions now, but then please know we will answer these questions at the end if we don't answer them right now. One question here is just if you moved during COVID. So the district that you lived in when the deprivation occurred is the district that's responsible potentially for compensatory education. So if you moved in the middle of COVID, you need to look to the old district for the period of time you were there and things that weren't provided, and then the new district for the period of time you were there if it was in the middle. One person asked if they could get monetary compensation. It's not generally monetary compensation, it's compensatory services. So getting those services. Now, if you, because they weren't giving you the speech, if you were able to find a speech therapist to give speech and you paid for that, you can ask for reimbursement of those expenses as the compensatory education. But it's not like there are monetary damages that in general, in our area of law, in general, I'm not saying there are some things that can happen that are different, that are where you're talking monetary damages, but in general, when we talk about compensatory education, we're talking about services, educational services that weren't given and that are going to be made up to the child.
I just want to,
yeah.
There's one question, what about comp services if the IEP was insufficient?
Yeah.
So this is something that was recognized and established even prior to COVID, that if you have an IEP and it's insufficient and you can demonstrate that the child needed a different type of intervention, more intensive intervention, or a different type, or he needed or she needed a certain related service, that you could still demonstrate that, and that would still allow you to be eligible for compensatory education if you can demonstrate that they needed that. They weren't provided FAPE because their IEP was insufficient. No, that makes sense.
It-
So
it-
it's not
yeah.
just about the services not being provided, it's about the IEP being appropriate. And how the IEP would be appropriate is if it addresses the child's needs. And if the IEP doesn't address all the child's needs and they're not making what's called meaningful progress, then you can demonstrate that they needed some other type of service, additional services, or some other type of service or related intervention services or related services or interventions, and that can be part of a claim for compensatory education.
There are really two different types. There's what we've been discussing is called a failure to implement the IEP. So they give you, where you sit down with the IEP team, you make this IEP. That's basically what the district is agreeing is FAPE. You may not agree. You may, like this question asks, you may not agree that that IEP was FAPE, but that's the minimum. That's what they're saying is their obligation to you. So at the very least, they have to give you what they're saying that your child needs in order to make meaningful progress. Okay, so let's go. We'll just finish the slides quickly and then we can get to the other questions. Do you want to get to the next? Thanks. Okay, so we wanted to touch on this. I'm not sure if more people came with older students into the room, but there was at least one family that did have an older student. So during COVID, the children that were in transition programs, these are these programs where they're out in the community and they're doing job sampling, or they're taking a class at a community college and learning how to advocate, like all these sort of in-person types of skills. Those kids couldn't do anything, like they couldn't go to any of it. So the legislature, with a lot of very, very strong and good advocacy from families, passed a law that any of the children that were in the transition years, meaning that they were going to graduate either in 2021, 2021, 22, or 22, 23. So the kids that would be graduating this year, they were in their first year of transition, right? So those kids that, because they missed all of that, on the ground learning, that they were going to provide those kids an extra year of entitlement and an extra year of services, like a whole extra year of their IEP, basically. And the reason that they actually had to pass law was that at 21, under the law, you age out of this education entitlement. So in order to extend this year for these certain students, they had to pass this law, and they actually passed the law and funded the law. So if an IEP team meets, and this is again relevant now just for the students who would be aging out of their entitlement this year, if they say, well, that first year of COVID, my son or daughter was in a transition program, they weren't able to do any of it, like they just didn't get the benefit of it. And so they only got 2 years of transition instead of 3, or maybe it was even less than 2, because there could have been, even into the next year, there were some things you couldn't do. If the IEP team agrees, they can extend the IEP for a whole nother year of this transition program. And they shouldn't fight you on it, because honestly, like, they don't have to pay for it at all. Like, they pay for it and then they get reimbursed in full from the state. So it's not coming out of any of the dollars that are going to go to special education in their budgets or anything. I think they have to pay in the beginning, and then they get reimbursed like midway through, and then they pay midway through, and they get reimbursed for the rest at the end. But they get all the money back, and it has been working. There was a little nervousness about it at the beginning from the districts, like, would they ever see this money back from the state? But they are seeing it back. So if you are in that situation, you should, they shouldn't push back on you too much, because it's not going to cost them anything. So that's what we've been finding in practice. But you have to ask, and you have to say that your child needs another year of transition. Do you want to go to the next? Another thing, and be interesting, actually, people can tell us in the chat if they've had these meetings, but the Department of Ed told the districts that they had to hold an IEP meeting no later than December 31st, 2022, this school year, or earlier if the parents had requested, in order to discuss compensatory education. They had to send notice to the parents to indicate that they were going to meet to discuss compensatory education for the period between March 18th when schools closed and September 1st, 2021. And then they were supposed to provide written notice. This could be in the IEP itself, this written notice of any determinations of compensatory education that the team met, that they considered what happened during COVID with the students' education, and that the team agreed that compensatory services would be whatever the team agreed to, right? And exactly the frequency, the duration. So they agree that they would provide 10 hours of Orton Gillingham instruction, compensatory education to make, whatever it was. That should have happened for everybody. We have heard of it happening for clients. It's not that it's never happening, but it certainly doesn't seem like it happened for everybody. I also want to say that determination by the district, just like many other determinations of the district, is something that a parent has the right to file for due process. So just because the district, like you may come into that meeting or have come into that meeting and said, my child missed, 40 hours of Orton Gillingham. I want you to make up the 40 hours of Orton Gillingham. And then the team says, oh, well, for whatever reason, they don't think they need 40 hours and they're going to make up 10 hours. And they put that notice. You have a right to challenge that determination in due process, just as the same as you have the right to challenge that the child was not given the right program or didn't wasn't given an IEP at the right time, or that the district's trying to take the IEP away. I mean, there's all these different points of decision-making, and at all those different points of decision-making, including this decision about comp ed, if you disagree with the district, you have the right to file for due process and, get a judge to decide. I mean, in practice, a lot of these things, you get mediation, you get settlement conferences. Many, 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 many of these issues are resolved without going through a full trial, but you have that procedural right to advocate for what you believe your child is entitled to. Next slide. Okay, so what I do want to say, though, is that with that right for to file for due process, there is a statute of limitations for how long you have in order to file. Generally, for pretty much everything, it's 2 years. You have 2 years from when something happened to file. However, we were coming up very quickly on 2 years since COVID started, and districts hadn't even thought about compensatory education, let alone met with any parents or done anything about it. And so the districts and the families, because we also, on our side of the fence, we were like, this is going to be like all these people filing for due process because people haven't even been able to talk about their districts and they're not going to want to lose their rights. So the state actually extended the statute of limitations for any COVID loss or comp ed that the parent is claiming for their child between March 18th, 2020 and September 1st, 2021. You have until September 1st, 2023 to file for due process to say that you don't believe that they've given your child what they're entitled to, if that's what you believe. So I'm going to throw out there that there are some people on here that did not have this meeting, right? So you didn't have the meeting, you can still ask for compensatory education. You can write to the director of special education or your case manager or both, and you can say, I understand that I was supposed to have this meeting by the end of December for this calendar year. Nobody ever contacted me. I didn't have a meeting. No one ever asked me about compensatory education. This is what my child lost during COVID, and to the best of your ability, try to write what you believe wasn't provided. I mean, you're not the holder of all the documents. So you can just say, this is my best estimation of what wasn't provided. But, between this date and this date, my child wasn't provided any services, and their IEP said they were supposed to have, an in-class resource special education teacher for this many minutes, and they were supposed to have this many hours of related services, whatever they are, and try the best you can to figure out what you believe that your child needs. And you can add to it, like Judy was saying before, and my child, had significant regression in behaviors because of COVID. And my child has, even today, not even gotten back to where they were, or are just getting back to where they were before COVID. And there was so much learning loss. And then ask for what you want. It can be a one-to-one type of situation of what you didn't get, or you can say, I've thought a lot about what my child would benefit from now to make up from that deprivation of services then, and then ask for something that you believe your child is going to benefit from, right? Because, I mean, these are kids, right? Like they have a day, they're getting hopefully what they're entitled to now and going to school. And they may have after school things that they like to do or that they have to do. And so there's only so much time in the day. So I would say, there's the what you're entitled to part, but then there's also the looking at your child part and saying, okay, what do I think my child would benefit, from now? You might say, well, there's like an ESY can't, if they're entitled to ESY, they can't be like, oh, well, ESY is comp ed, because the ESY is something they're already entitled to, right? But they could say, well, ESY is 4 hours, but we can give your child an extra hour a day of a social skills class or of speech or more of this, or we can extend it throughout the entire summer so they, something that will be not just, we don't want them to have, a 10-hour school day. So try to think about, what you feel your child would be helpful to your child, and then ask for that for compensatory education and let them respond, since they haven't come to you about it. And then I think there's one more slide, and then we're going to turn to all the questions. So we wanted to mention this. It was sort of an issue at the beginning of COVID that some school districts were trying to have parents sign waivers that if they were going to get remote services or speech or whatever remotely, that they would have to sort of waive that, that they wouldn't ask for compensatory education. And as someone asked about earlier, and Judy touched upon, I mean, just because they gave you speech and some speech therapist got up on the screen doesn't mean your child was participating and was able to do it, because some kids just couldn't do it. I mean, honestly, some kids did great with the whole virtual thing. Like I had some kids, especially kids with severe anxiety, that just did fabulous during COVID with this whole virtual learning. So did they need compensatory education? No, because they made progress and got what they needed. But then there were other kids who just were not able to engage that way, and in the worst cases regressed, but even in those in not the worst cases just did not make any progress. So it's not just about, well, we gave the speech therapy, it's about whether that person was helpful. So if any of you did sign one of these waivers, we just wanted to mention that you should still ask for compensatory education. Those are not valid. So I'm going to turn to some of the questions here. Regression does not only have to be in academics, it can absolutely definitely be behavioral and emotional and social. Those count also, especially with obviously with some of the diagnosed types of disabilities. If you're talking for a child with ADHD or anxiety, depression, or autism, then of course those behavioral things are part of the disability, or they might have not had that disability. The other thing to mention too is they may not have had mental health disabilities before COVID, but they may have them now, and they also still have to deal with the child always as they present. So if things happened aside from compensatory and what they might owe for the past, if the child has different needs now, the IEP team and the IEP are supposed to be addressing all the child's current needs. And it's not like it has to be because they were born with something. If you developed an anxiety disorder because of COVID, now you have an anxiety disorder. It's a diagnosis and it has to be addressed.
I just want to add to that the IDA, it's sort of a broad umbrella on what special education covers. So it's all about raising children, raising students so that they can become independent adults, or as independent as possible, functioning adults. And under that umbrella, that is not only learning math and English or science, but it's also learning how to socially engage with others. It has to do with learning how to cope or address behaviors. It's very broad of what the IDA covers. So regression, if you had, for example, goals and objectives already that related to behavior or emotional and social aspects of the student, then definitely the regression, the fact that they're regressing is relevant to the comp ed claim. But also, as Denise was saying, even if it's not one of those things that had been identified in their IEP, it's certainly, you have to update the IEP so that it is relevant and addresses the current needs of the student. And that might be that they have, have new behaviors or have new social emotional needs.
I'm sorry.
No, that's okay. Do you want to?
Someone was asking, how can we measure and let the IEP team know that there are new challenges to the child in behavior with the mix of online and hybrid education? So, there are different ways of letting the school districts know what's happening. There may have been contemporaneous emails between you and the teacher, you and the case manager, things that were happening then. There may be, either like pediatricians or psychiatrists or psychologists or counselors that were involved that could write a letter about the impact of the lack of learning or the social isolation or, whatever was happening. As far as accounting for all of the missed sessions, you can also ask the school district to provide you with the list of sessions. Let's say there's a situation where when you did get the speech therapy online, it was great. It worked for your child, but you just didn't get what you were supposed to get. So you're not claiming in that case that all of what they provided was bad, because it was fine for your particular child's needs, but they missed, 20 sessions before they got their act together and they never made them up. So if you can ask them if they can provide you with an accounting of the missed related services or missed services from the IEP, so that you can, see, kind of compare it to your own notes. You might have some notes that, from the time, from calendars or whatever of what was happening, or emails that there was a lot from March to June. There were there was that March to June. That was when most people didn't get the most, right? Because the schools were like, they didn't know what they were doing. They didn't know if they were going to be opening again. They didn't have anything in place. There were kids that didn't, if your child didn't have access to a computer or you didn't have access to internet, this whole calculation, it's not about being anyone's fault. It's not about being the school's fault or being the parents' fault, or it's not about fault. It's about the IEP team sits down with you as a member, as the parent, and decides that in order for the child to receive an appropriate education, again, at a minimum, they need to get the services that are in the IEP. And then this thing happened, which upended everyone's lives, and some people rose to the occasion more than others. Some school districts did a better job than others getting themselves organized, but everyone was trying to do the best they could under a very, very challenging circumstance. So it's not like there's a bad actor and you have to show that anyone was at fault or that they can say that you were at fault. You know, if you kept your child home when you were allowed by the governor to keep your child at home, and they say, well, we were open and you could have sent your child to school and then your child would have had that service. Well, no, that's not okay, because you were under your full right as a parent, just as every other parent was under that right, to keep your child at home because you feared for their safety or someone in your household, or there was a lot of different reasons people chose different choices with that. They can't then say that you're now not entitled to compensatory education because you made that choice. So it's just about trying to say, like, I'm not blaming anyone. It's not, no one's mad at anyone. Like, this kid was supposed to get these services. This thing happened. They're supposed to get it made up to them so that they can make the progress that we want them to make.
There's another question. It says, do we need an advocate to go through the process with the district? I'm assuming that that means the process being filing a petition for due process. So, you know, you're asking advocates. So, but with that caveat or disclaimer, you know, that you can do it on your own. You can represent yourself and file a petition for due process. If you go to the New Jersey Department of Education Office of Special Education Program website, they have what is needed to file. They have sort of a step-by-step guideline on how to file on your own, or what we call pro se. I don't recommend that. We don't recommend that. You can certainly do that. I think a better way to go if you're trying to save on cost is there's volunteer lawyers for justice. And if you qualify, you might be able to get assigned a pro bono attorney for your case. I think that's a better way to go. There's also many advocates out there that are not attorneys that are less costly if resources are an issue, and you might want to look those people up. The special education advocates in New Jersey, there's several that I know of who are very, very good. And so those are other ways that you can get representation without having to expend the resources for an attorney. But like I said, you can do it pro se, and the Department of Education does have a guideline of how to file the paperwork, and there is a form online for the petition for due process. But again, what's going to happen is the district has representation. They're going to have their attorney there, whether it's at the mediation or at the settlement conference. And so you're at a disadvantage. So I do recommend that some type of representation be attained, some kind of advocate, whether it's through a pro bono program like Volunteer Lawyers for Justice. There also possibly might be an opportunity through the Rutgers Law School has an education and law clinic. Possibly through them you can get, if you qualify, because I think there are pretty strict financial requirements to qualify for the pro bono representation, or if you get an advocate who would be less costly than hiring a special education advocate, less costly than hiring an attorney. So
Judy, I just want to jump in and mention that before a parent gets to the point where needing to file for due process, if they just need document review, if they want an advocate to look over a letter that they're drafting or help them brainstorm that letter, the Alliance has a free advocate who can work with them. Once it reaches a point of a disagreement that is entering that mediation due process situation, we step back, but we can help you do some of that planning and preparation on the front end. And that's at no charge.
that's great. I would take advantage of that.
I also put Volunteer Lawyers for Justice link. I see someone put SPAN advocacy training, SPAN advocacy in the link. And we do maintain at the Alliance a long list of special education attorneys and non-attorney advocates. I see someone asked that question. There are obviously attorneys, And then there are non-attorney advocates who can provide special education support.
So someone else has a question here, basically that, the school is saying that the student doesn't need compensatory education, that he did fine, even though he only had a half a day and didn't have all of what he was supposed to do in the IEP. We're seeing a lot of this, like the schools, the districts, I think, are so overwhelmed with the potential claims that a lot of them are just saying, well, it was the past, like it's over, the child is fine, these are the things that you can file for, if you can't work them out, you can file for due process. And at the very, least, you get a mediation, you get a settlement conference. You don't have to decide whether or not you're going to go through a full trial, either with a lawyer, an advocate, or pro bono, to file for due process and push the issue and try to get them to come to a settlement with you. The mediators and the settlement judges all try to settle the cases, to find a compromise, common ground, because honestly, they don't have enough mediators, they don't have enough judges to try every case that's filed in New Jersey. So they're settling probably 85-90% of their cases. So if you're really getting, just say like, oh, COVID, what was that? And your kid is fine, even though you have documented that the child did not, get what they needed. And, it's not about whether they regressed during that year. It's like, if that year hadn't happened, if there hadn't been COVID, they would have gone to school, they would have had all those services. We'd like to think that they would have made meaningful progress based on those services. Again, maybe they weren't even enough, and maybe they should have had more or different or better. And that's always, that is the bread and butter of why people come to us, because they don't feel that what they're being provided is the appropriate service and support for their child, and for their child to thrive and to make progress in the areas of need. Okay, so that is always there. And that's the common reason why people do file for due process. But, this is, we have half a year left, until September 1st and this is a right. And it is your right to ask for these services from your school district that were not provided to your child, or that, because of things getting worse, you had to provide more or different, or, other services.
So
I'm
there's a
getting private messaged by a lot of folks asking about the link to the recording, which means that people want to rewatch this. I'm going to go ahead and post where that will be in the chat.
There's
This won't be up till tomorrow, but by tomorrow we'll have that. You'll have to scroll down, but that's where it'll be.
Yeah, there's a lot of, I always feel with these presentations, sometimes there's a lot of information. It's very dense, and it's a little not complicated, but it's complex, and it's always helpful to, I think that's a great idea to rewatch this and to look at the slide presentation. There is a question about the types of compensatory education to request. So for example, someone asked, what kind of compensatory education should we request when regression is behavioral? And so, the types of, and Denise might have a different perspective, but I think that I rely a lot on the experts, professionals who know what is necessary in order to address the deficits or the regression in a child. So in a student, I think that in addition to saying, okay, maybe they weren't able, or actually the question asked this, they were provided services, it was online and hybrid. I think sort of documenting or recalling how the child either, struggled with accessing the interventions that were provided online, or how they missed half of what they were supposed to be getting through hybrid is important, and factors in towards the regression. So It's
It's
sort
not,
of like,
I mean, not necessarily even regret. I mean, if it was regression, but it could have also just been lack of progress, but you should also have progress reports. So the
Right.
progress reports for many of this time were blank or were, not introduced or, that shows that the child wasn't getting the services or that if they were, the services weren't effective. So you can look back at the progress reports also that you have from the school and see what they were saying about what was going on. I mean, there may be comments from the teacher in the progress reports or in the report cards. Oh, so your child wasn't keeping their camera on, they weren't engaged, they may have provided you with the support for what was going on because they were hopefully trying to engage the child or get them to turn their camera on. There were kids that need an aid and they weren't given the aid, and now because they weren't given the aid, they were at home and the parent worked, so they couldn't sit there next to the child the entire day and the child didn't participate in the instruction. So again, it's not about blame, okay? It's about whether or not the student benefited from their IEP. And if they didn't, for whatever the reason, whether they weren't given it or whether they were given it and couldn't access it, then you can ask for compensatory education. And I just, I urge you to think about what that should look like that would benefit your child now.
and it could be in that instance that it's it's a more intensive intervention to make up for that time period, and so that they can make the gains that they need to be in the place that they would have been if they had received the services. So that's key. I think that's standard, and that's why I highlighted it on one of the previous slides, that the Third Circuit has talked about what compensatory education, what the purpose is. And it's to put the child in the same place that they would have been if they had received the appropriate program. So that's really key. And I think it's a combination. I don't find progress reports, the formal, fill in the blank progress reports where they have like a standard response, that helpful, even without even talking about COVID, just in any event. I think they're very difficult to base a lack of progress on, or to show that there is progress. I tend to think that, and I advise clients in getting as much information as possible. For example, if your child was in a program, an ABA program provided by the district or an out-of-district program, they were collecting data. They're supposed to. That's what an ABA program is all about. It's about collecting data on behaviors. So I would recommend that you do a formal student records request and request that data so you can see. The data will show you if there's been an increase in certain behaviors, if there's been a decrease in some behaviors, and then an increase in new behaviors. And it should be that they should have been collecting that data. So, and that's very helpful to show whether they made progress. It's also helpful, as Denise was saying, that to find out the records of maybe the teacher was commenting or in notes or communications that the child is the student is acquiring new behaviors that are maladaptive and interfering with their learning or what have you. So it's very useful to do a records request, to look over the student's records, to look for the data. That tends to show or indicate whether the child is making progress, whether they're stagnant, whether they're regressing. And it also tends, a lot of times you can find out whether services have been provided and whether they've been provided with fidelity pursuant to the program. So
I would also just want to mention that, some people are saying the progress reports have nothing in them. They don't say anything. They're the ones that need to show that they did give the services, they did give the FAPE. The parent, the burden in New Jersey is on the school district to prove that they provided the student with FAPE. The burden isn't on the parent to prove that they didn't. Now, I'm not saying like when you do these things, you do try to provide, as a parent side, all the things you do have to show that the district didn't do what they were supposed to do. But if they don't have any proof of progress, then that's their issue too. It's more their issue because they're supposed to have the data, like they're in control of the program and the school. So they're the ones that are supposed to show that the child made meaningful educational progress. And they can say it, they say it sometimes, oh yeah, we say, but they need to prove it if you push the issue and you're going to go before a judge. They have to show a judge proof that the child made progress. So, if they don't have that's really on them. And it's a problem for them because how are they supposed to prove that the child made progress if they have no data to support that?
Denise and Judith, I have a direct message question here from a parent who has a son was in a self-contained autism classroom when COVID hit. There was zero academic instruction and speech/OT started virtually towards the end of April. Academic instruction started virtually only in ESY. And then her son would not have been able to engage with this without the aide that she hired to sit with him because he had an aide. He did actually progress, but only because this parent had to spend a large amount of money to assist him. So how does this fit into the idea of comp ed, but not necessarily comp ed education?
So you can ask for reimbursement for expenses that you incurred in order to that they weren't providing. So if parents did provide services like that, that parent can ask as comp ed to be reimbursed for the cost of the aid. That the aid was needed, that the child clearly, did the child have an aid in the IEP? If the child had an aid in the IEP, that's even more, I think you could make an argument anyway that this child would have been in a very, very small, there was probably at the minimum a shared aid in the classroom, but if the parent hired, if the parent hired an aide or if the parent paid for certain services that the district would have been providing and didn't provide because of COVID, then you can ask that's not considered like money damages. That's considered reimbursement for educational expenses.
So we are fast approaching the 8:15 time mark. I'll ask if our guests will just maybe take one more question out of that list of questions. I know there are many. And then we will get ready to.
I mean, this is a quick one that someone's asking that if your child is out of school, someone's saying their child's been out of school because the school district has not been able to provide a program. And that does give rise to compensatory education for all the days that the child is out of the program. So again, that's something that can be handled in different ways. We have times where there's a lot of comp ed, but we want the child to be placed in a better program than what the district is offering. And we sort of trade the compensatory claim for that better program going forward, because we feel that the better program is going to make up to the child what they missed out from the compensatory claim. So these things are sort of resolved, I think, creatively in to benefit the child, but certainly compensatory education is always a remedy if a child is not being provided with free appropriate public education. So if they're out of school right now and they have been out of school since January, then there's, all the days that they missed of compensatory education, which the child is owed. So that would be yes.
Well, thank you both so very much. There is stuff I thought I knew a lot about this, and I learned an awful lot. So I really appreciate you joining us tonight. I know the families on the call, they've stuck with us. So the content is so useful, so timely, and your expertise. We just can't thank you enough for being here tonight. We will be posting this to the Alliance website tomorrow. And just so that you are aware, we are going to be letting the folks at Parles Rekem reach out to you one time to invite you to sign up for their email list or any other seminars and workshops that they might offer, so that you will get an email notice from us with a link to this event and an email notice from them inviting you to follow them if you should choose to do that. So you'll
Brenda, Can I just answer one more quick question?
Oh,
Someone
sure, absolutely.
Someone just asking, like, when do you get a lawyer? Like, that she has a question about camp services and when do you get a lawyer? And I think about that a lot also, because like, I certainly, we have people to come for a consultation, and we charge them for an hour of our time, which is $4.75. And then we we read all the documents beforehand, and we spend, an hour or more with them, and we sort of go through what we see in the actual documents. And there are times when it's like, well, the only issue is really this camp program. Would I have someone pay me to advocate for that? Probably not, because I don't want them to advocate for something and pay me when they could just pay the camp. So there is, there is if it's just about a small issue, you can, I will advise them how to set it up the best way, what kind of words to use, like, looking at different arguments that they could have, maybe that the camp is compensatory education because of something missed, we'll make it up that way. But, certainly if you're mostly happy with what's going on, and there's this small thing, once a week speech therapy, and your insurance pays for it, but there's a copay, like, would you hire an attorney for that? No. I would say no. Like, so there is a balance there. So I just wanted to say, we're very judicious with that, because for us, the child needs to get the services. So if I'm ever at all concerned that, like, the case is going to take the money that would go to the child services, like, we don't take those cases. We tell the parent, it's not cost effective, and that they should just, we try to help them set themselves up to try to get to yes, or maybe talk about how they can broker a compromise where maybe that they'll pay for half the camp, or, there's lots of ways to sort of try to resolve these things with the school districts, that it's not always like an all or nothing scorched earth kind of a situation. So anyway, sorry, I just wanted to, I saw that.
No, it's actually a beautiful way to end it, because I think reminding folks that it is a collaborative process. It is not black and white. There's a lot of gray, and there's a lot of different ways of solving problems that don't have to ruin relationships or bank accounts. There, really are some collaborative and creative ways of approaching this. So that's a great way to end things.
I just also want to thank you, Brenda, and thank you, Susan, from both organizations, for putting this presentation on. And also there have been several others that I think are really useful and valuable to the community. So
good. Yeah, we think that the time is just right. And from the thank yous that are coming in, I hope you're seeing that. People really did get a lot out of today's program. So thank you both. I'll wish everyone a nice evening, and please do join us on Saturday, March 25th at the Alliance Resource Fair and Family Fun Day. We're going to have Elsa the Ice Princess, and Coco Melon, and Cookie Monster, and Captain America, and balloon twisters, and 50 vendors. Our advocate is there if you've got questions. It's a great event. So check out our website. It's free, really fun. And there's staff there who can kind of watch your kids while you're doing the circuit around. We do have like a play pit with volunteers. So please do join us. All right. Thank you very much, and good night.
Good night, everyone.